It's the Law.
Welcome to It's the Law, a program produced and presented by the Guyana Association of Women Lawyers. On this program, a member of the association gives us an in-depth look at Guyana's laws. On today's program, we hear from Keisha Chase, who has been in the profession for 12 years.
Hello everyone, my name is Keisha Chase, attorney at law, admitted to practice at the Bar for Guyana. I'm also the treasurer for the Guyana Association of Women Lawyers, and I'm here to speak on the topic of division of property. Division of property is considered a legal concept where parties own property during a union. Now, even though we are together, I may have it in my name, holding it in trust for both of us. The Married Persons Property Act speaks not only to married persons legally, which a certificate of marriage is issued, but also to common law spouses, parties who have been together in excess of 5 years, living together and treating each other as husband and wife, single parties. Applications for division of property are only made to the High Court of the Supreme Court of Guyana. These applications are filed at the Family Court of the High Court of the Supreme Court of Judicature. At the Family Court Registry, an application can be made in person or through your attorney. These applications refer, as I said, to a man and woman who are legally married and a man and woman who are either single, widowed, divorced, or never legally married but live together as common law spouses. Married Persons Property Act deals with property that is owned in equal shares, jointly, or solely in the name of one person. Some orders that you may apply for at the family court include a declaration that the person who is named on that legal instrument, either transport, title, or lease, that they held it for both parties. You can ask for a declaration that you are a part owner of that property. You can ask for declarations that you be given possession over the other party, or you can ask that your share be sold or bought by that party, sold by you, bought by that party, or even sold to a third party. You can also ask for your share to be transferred to your children, to your mother, to any other party, or sold to that person. So applications for division of property. Let's deal specifically with where property is owned by the parties jointly. Jointly means we each own an undivided half share. Now, you must approach the court for severance of that joint ownership so that you're able to deal with your undivided half share. When that severance is granted, you may ask the court then to have your share sold to the other side, which is your husband or wife, or that it be put on the public market and sold at a market value. I will deal with valuations later into our conversation. Let's specifically continue with the joint ownership. Joint ownership, the only thing you have to prove is that there is a legal instrument with your name and the other party jointly. That is all. You need not prove that you made any contribution to that property. You need not show that you have done anything in relation to the acquisition of that property. And when I say acquisition, I mean purchase or gift. If somebody gives both of you and it is jointly, I own it just as much as he or she may own it. The issue arises in the court most occasions when a property is held by one party. Now, if a property is owned by one party, the first limb that must be proven is that that property was acquired during your union. If we got together in the year 2000 and that property was acquired in 2002 and we were still together, we continued that relationship for another 2 years. That is sufficient to show that the property was acquired during the union. It is easier to prove acquisition during a union if the parties are married. It is a little bit more difficult to prove when it is common law spouse. There is always one saying that the union did not start at a certain year, it did not end at a certain year, simply on the basis to satisfy the court of the 5-year union that is required. Some courts have been going beyond that 5-year. The courts examine what the intention of the parties are. When he put it in his name or she put it in her name, the intention was for us to treat this as our home, our children's home, what we have acquired, compiling our resources. And this does not mean both parties have to be working. A housewife is considered a job, and we all know how much that person does, especially if children are involved. The court are human beings. We all live in a society where we know that persons stay at home to care for the home and children, and the other person works at a job or their own personal employment. So for sole ownership, after we have proven that the property was acquired during the union, the court looks for the share to be allocated to each party. One may have more than a half share if it can be proven that you have done more for the acquisition or improvements to that property. When I say improvements, if you have applied for a mortgage and you continue to pay that mortgage sum every month, and if it had not been for the granting of that mortgage, the development of that small 1-bedroom could not have been 3 bedrooms. So that is a contribution to improvements. Now, these two considerations are also looked at by the court if I met my partner with property. If I met him or her with a home, and that home again was 1 bedroom. We have been together 7 years, and it is now 3 bedrooms. We have 2 children. We have extended the kitchen. The living room is now tiled. The court looks at all of the improvements from the time that you commenced your union to the time that it has been terminated or determined by one party or the court. That is a consideration for the court, the improvements, your contributions therein. If we have purchased the property, I went to the bank. I may not be on the title, but my name is on the mortgage deed. For the granting of the mortgage, the bank considered, or the financial institution considered, both parties' income. My name may not have been stated, but for the acquisition or the purchase of that property, my name had to be on the mortgage deed. That is further evidence that you contributed to its acquisition. A court's decision on principles which may apply for the applications for division of property are, I may have stated it earlier, but I will state it specifically in 5 points. How long the 2 persons have lived together. Whether or not you have worked outside of the home. Whether you have lived together for less than 5 years. There, the court has to take into account the contribution to the union and the welfare of the family. This includes any contributions of caring for the home and the family. That is what I spoke about with respect to housewives. We're now having house husbands, so that is also a consideration. If you have lived together for more than 5 years, but you did not work outside the home, the court would award 1/3 of the property to you. If you have lived together for more than 5 years and you've worked outside of the home, the court starts the award at 1/2. Again, if there can be evidence to the court showing more contributions by one party over the other, the share may increase and decrease depending on who that party is. When a property is owned jointly, proceeds from the selling of one party's share may be made at a court, may be lodged at the court for the uplifting by that party. For us to even reach the proceeds, we must have a valuation done. This is done either by a private valuator or it can be done through the Government Valuation Office on Camp Street. Mr. Barrington is the head of the Valuation Office. Most applications for division of property, there must be a starting point to determine shares. The court orders that the valuation be done through the government. the expenses for that valuation is split between the husband and wife or the parties in the application to the court. When that valuation is prepared and it is served on each side, then settlement talks may commence. This is encouraged by the court. The Family Law Procedure Act in 2016 that came out, it was more for amicable resolutions as it related to family matters. The courts try to have parties speak to each other. We would involve mediators through the mediation office of the High Court. A matter can be referred to the mediation office either by consent of the parties or by an order of the court. It is encouraged for parties to go to mediation. This allows parties to speak their mind freely. It is not held against them in a court of law. It cannot be used against them in a court of law. It allows for whatever underlying issues that may have arisen during the hearing of that matter or since the termination of the union to be addressed by a trained mediator provided through the mediation office. General rules which apply to ownership of property during a marriage. You can continue to own property which you had prior to the marriage. I spoke on if a party wishes to have a share in that, they must prove contributions to the acquisition or the improvement. If a property is bought in both names jointly, again, you own an undivided half. Without the consent of the other person, one cannot sell, mortgage, lien, or dispose of that property once it is owned jointly. If a property is owned in equal shares, you own an undivided half. Again, the consent is required. These two differ in terms of when one dies. If a property is owned jointly and one party dies, we have here in Guyana the law of survivorship, which simply says as that person dies, the entire property falls to the other. If a property is owned in equal shares, now in equal shares, if one party dies, their undivided half falls to their estate. And one of my colleagues or myself will deal with estate issues at another stage. But simply estate means your spouse, your children. If there are none, then it goes solely to your spouse. If there is a will, then that will determine how your undivided half share is dealt with. Fourthly, if your legally wedded husband buys property, puts it in your name, there is a presumption that you are holding it for him and yourself. Again, if your wife buys the property and she puts it in your name, the husband name, the presumption is she is holding it for both persons. That presumption can be rebutted with evidence of the acquisition of that property. If a property is bought in the name of your wife or husband, but you have improved it more, you have contributed to the acquisition more, then again, the court considers that when awarding the size of your contribution for a share. No person goes into buying property with their wife to exclude her from a share into that property. No wife goes into a marriage, buys property to exclude her husband. That is why the most important consideration for the court is the intention of the parties. Now, the intention can be gleaned from an examination of affidavits filed in the matter by the parties or oral testimony in a witness box. The court is not a court that has never heard of division of property matters before. So they know what they're looking for in terms of the evidence that is alluded to by each party in their oral testimony. Applications filed for division of property, they are filed again at the family court. You can file them in person or through an attorney. The applications filed therein, if it is that you are married, you can attach your certificate of marriage. If that marriage has come to an end, you can attach your orders from the court showing the granting of the termination of that marriage. All applications must be served on the other side. They must be given time to respond to any allegations therein. There are different means of approaching the court. For example, if a property is owned jointly, you can file another application to the court, but through the civil division, not the family division. That is simply saying that the property is owned jointly and I wish to have that severed and I receive money for my half share. That is a faster application to the court. It is filed under the Immovable Sale of Interest Act, which is also considered in the family court. But those applications can only be made where there is a title held jointly. Now, if you own property solely and you have been divorced, you don't have the finances, you didn't think that one party would try to put you out because your name is not on it, you have 3 years in which you can apply to the family court for a division of property. On the expiration of that 3 years, it does not mean you have lost your right. It means that you have to now go within the regular jurisdiction of the High Court and file a claim for declarations that you are entitled to a half share, declarations that that person who's on it held it for the both of you. And the only reason for coming to the court in this manner is because the 3 years have now lapsed. It does not mean you have given up any right. I'd advise any person that has property with their spouse or without their spouse to seriously have conversations during that union as to what we will do if somebody is to pass away, that is if it's in equal shares, or if the union no longer satisfies both parties. Approaching the court should be a last resort. You can come to an agreement between yourselves. You can have it in writing. You can visit an attorney. You can even make joint applications to the court to deal with your family issues. Not every issue has to be contentious. Just keep that in mind. Thank you.
You have been listening to It's the Law, a program produced and presented by the Guyana Association of Women's Lawyers. Today's contributor has been Keisha Chase. The contents of this program are not to be taken instead of legal advice.